Our first case this morning is Salla v. PNC Bank.
Good morning, Mayor. Please the court. I'm Mark Stopa, counsel for the appellant. I would request 5 minutes for rebuttal.
Okay, thank you.
Thank you, Judge. Your Honor, I submit there are two reasons why this summary judgment of foreclosure should be reversed. The first is based on the plaintiff's failure to conclusively prove its standing to foreclose. The essence of the problem in this regard is that the copy of the note attached to the complaint did not contain any endorsement from the original lender. In fact, the original note, which was filed in the court file...
Well, it did, but it was on the reverse, it was on the back of a page.
Well,
it didn't get scanned in.
Well, we don't know that. And at the summary judgment, there's actually a case called Guzman out of the Fourth, which dealt with the same fact pattern. There it dealt with it in the context of trial. And I think it's important to note that the Fourth did not just presume that the copy was, that the endorsement was on the back page of the note, because there wasn't anything in the record that established that. That was even in a trial context. Here we're in a summary judgment context where we are entitled to all inferences, and I submit that when there was not any record evidence at all that that endorsement from the original lender existed in the condition that it later appeared in the case at the time of the complaint, that created a problem for my opponent, which should have been fatal. There's certainly not any cases that they can point to which support the proposition that, well, you can just assume that that endorsement from the original lender was on the copy of the note attached to the complaint at the time of filing. It wasn't on the original note as filed with the notice of filing original either at record pages 319 to 322. So on that fact pattern, I submit that Guzman is the case that is the persuasive authority. There's not any authorities they can cite to the contrary. And their argument predicated upon the Ortiz presumption hence has to fail, because the Ortiz presumption applies when the copy of the note which is attached to the complaint exists in the same condition as that which is subsequently used at the dispositive hearing or trial.
So what was your objection that preserved your argument in the trial court below?
Well, we did file a motion for rehearing on these issues. There's no transcript, and my opponent certainly harps on that, and I'll get to that. But we filed a motion for rehearing before the final judgment was actually entered, which alerted the court to these issues, and they ruled against us anyway. And I submit that under this court's decisions in Houck, Kamen, and Johnson, all decided within the last year or two, all in the summary judgment context, they all reverse final judgments of foreclosure, notwithstanding the absence of a hearing transcript when...
Then what are the issues raised on appeal? The paragraph 22, proof problem, and standing at the inception.
Correct.
And you're arguing the standing at the inception first here today.
That's what I was presenting first, right? I was going to get to the paragraph 22, the lack of summary judgment evidence that the default letter was actually mailed. That also kind of dovetails with my transcript argument, because my opponent again tries to say there was no transcript to the hearing. This court's decision in Kamen, which obviously Your Honor drafted, I submit is directly on point in that regard. Let me start with the proposition that there are now many cases from this court which support the proposition that the mere existence of the default letter doesn't prove that the letter was mailed. There has to be separate evidence of mailing.
Here's my question. If they have testimony can, under oath, testimony can often cure a problem with the pleadings or the documents.
Well, sometimes.
But how do we know that didn't happen here?
Okay, well, because we're at summary judgment, and this is de novo review, and under the summary judgment rule 1.510, if your quote, personal knowledge is based on the content of documents, then those documents have to be attached to the affidavit. And here, if you look at the affidavit that my opponent was relying upon, it very clearly indicates not that the affiant had personal knowledge of the facts, but had personally reviewed the business records. And the affidavits, there were actually two different affidavits that spoke to this default letter issue. They were the mailing of the default letter. Both affidavits indicate that the default letter was mailed predicated upon documents. You don't have an affidavit where a witness is testifying based on personal knowledge. You have an affidavit where a witness...
But the affidavit says based on personal knowledge.
No, it says personal knowledge of the books and records. Paragraph 2, for instance.
He uses personal
Well,
the affidavit.
not personal knowledge of the facts, personal knowledge of the books and records. That's in paragraph 2 of Sharon Lynch's affidavit, for instance, or in the other affidavit, the affidavit that affidavit is just as clear. That's in paragraph 18. The loan records reflect that a default letter was sent. Well, as a matter of law, you don't have personal knowledge when your knowledge is based upon documents which are not attached to the affidavit. So both affidavits that they have, it's clear that the affiant doesn't have personal...
It's just the letter.
Right, but the existence of the letter itself doesn't prove it was mailed. That's Edmonds, Allen, Kamen, Spencer. This court has numerous...
How do we know that specific argument was made?
Well-
That's what you're saying now, but you're saying you made that argument on a rehearing?
That was in the written motion for rehearing, which was filed prior to the final judgment actually being entered. And I submit that the way you're asking the question is it suggests that there is an obligation to have a hearing transcript in order to show...
Well, it depends. No, if an error is apparent on the face of the record, I have no problem with that.
I mean, we are on de novo review, and this court has concluded you don't need a hearing transcript, and so I don't think I have the affirmative obligation to show you that was actually told to the trial court at the summary judgment hearing when we're on a de novo review, which is why this court ruled in Kamen that even despite the absence of a hearing, when the quote proof unquote of the mailing of the default letter was based on inadmissible summary judgment evidence or shouldn't have been considered because there was nothing attached to the affidavit. In that case, there was a default letter attached to the affidavit too, but there wasn't a mailing log or a screenshot or a notes log showing it was mailed, and there was nothing in the affidavit which laid out routine business practice of mailing. Here, this was a simple issue to fix. They should have done one of two things. They should have either had the affidavit recount personal knowledge of a routine practice of mailing. That would have fixed the issue because it was a PNC employee in a PNC letter. So recount personal knowledge of a routine practice of mailing, or attach a return receipt or a mailing log or something like that, to a document attached to the affidavit to show mailing. Without that, what you're left with is an affidavit on mailing which is simply hearsay, because what it does is it says these documents show that the letter was mailed. Paragraph 18 of the affidavit attached to the summary judgment motion. The loan records reflect that on or about March 18, 2011, a default letter was sent. Well,
Mr. Stoper, let me ask you this, because I know you've responded to both Judge Valenti and Judge Kelly. So looking at the affidavit, paragraph 2, the language, I make this affidavit based upon my personal review and knowledge of the business record. So it's your position that that statement is different from what needs to be shown that I have personal knowledge of whatever facts.
Right.
You draw a distinction saying that this is personal review and knowledge of the business records?
I do make that distinction. I don't read paragraph 2 of this affidavit or paragraph 18 read either individually or together as someone saying, you know, I saw the traffic, I have personal knowledge of the traffic light was green, I saw that, and I'm saying I have personal knowledge of these facts in an affidavit.
So
This is someone saying, I looked at documents, right? I personally reviewed and have knowledge of business records. It's all in the same clause, personal review and knowledge of the business records. It doesn't say personal knowledge of the facts of this case. It doesn't say I have personal knowledge of the circumstances of this situation. Personal review and knowledge of the business records, to me, all that means is that they looked at documents. And I think that paragraph 18, the way that that's worded, is consistent with that. And in fact, really every paragraph of the affidavit. Look how many paragraphs of the affidavit start out, the loan records reflect. Paragraphs 12, 13, 14, 15, 16, 17, 18, and 19 all start out that same way. You have 8 consecutive paragraphs that all start out the loan records reflect. So you have a witness who starts out the affidavit saying, I know what these documents say, and then the substance of the affidavit is essentially to recount what those documents purport to say.
Let's assume you're right in your interpretation. But then let's rewind and go into the summary judgment hearing in the prospect that, hey, the judge said this is a little bit inadequate. Can you tell me more? And it's just, yeah, this is what it really means. And the other side, which I'm going to guess might have been you, doesn't interpose an objection, or the judge overrules it and says, I'm interpreting these facts to mean this, that's my ruling, I'll accept the stipulation or the clarification, and we don't have the transcript. How do we get past something like that?
You know that couldn't have happened because it can't happen at a summary judgment hearing. You can't have testimony or clarifying testimony about what
I don't know that it's testimony.
Well,
I'm saying the attorney is making an argument as to the interpretation, and the judge is saying, well, there could be more than one interpretation. I'll go with interpretation A. Why wouldn't that be a judgment call?
The way you just asked that question proves my case, because if there's more than one interpretation of this affidavit, we're at summary judgment. That means we're entitled to all the inferences. So if you read this affidavit and you can't tell exactly what it says, then that means we were entitled to the inference about what it says in our favor. So at summary judgment, these are inferences if you're not sure what it
My question
says.
is hypothetical, but if it's otherwise clear on its face, you've got a gap in your argument.
Well, if it was clear on its face that the person was saying, I have personal knowledge of what happened regarding the mailing of the letter, then I would see it differently. But I don't see anything in here where this person is saying, I have personal knowledge of the mailing of the letter. And to me, that is what is necessary in this that simply isn't here. It's not like this person saying, I mailed the letter. It's not like this person saying anything in first person at all. There is no first person in this affidavit at all, other than in paragraph 6, where they say, I reviewed records. And just that, think about your typical affidavit in any type of case in the summary judgment context. If it's based on personal knowledge, it's someone who's saying, I did this, I did that, I saw this, I said that. You don't have first person in this at all. Every single paragraph in this that recounts any sort of facts is based entirely on the content of loan documents.
Let me follow up with that, Mr. Stowe, because that seems to be the language about and knowledge of the business records. As I hear your argument, you're saying they needed to do more, that I'm familiar with the routine business practice, and this is something more, that I have personal knowledge of that.
That's totally the way that I see it. Like, this is obviously a PNC employee and a PNC letter, so I don't think they had to attach a document showing mailing if there had been something in the affidavit that said, I am familiar with PNC's routine practice for mailing letters. Here's what the practice for mailing letters is, and that routine practice is followed in this case, something to that effect. But there was nothing in this affidavit about a routine practice of mailing either. So the absence of anything in the affidavit on a routine practice of mailing, coupled with the absence of any document showing that it was mailed, coupled with the reliance upon documents to prove mailing without those documents being attached are what makes this affidavit insufficient for summary judgment purposes and makes this case materially indistinguishable from the Kamen case that Your Honor drafted on.
So your argument really isn't that there's some issue that needs to be tried here. Your argument is that the affidavit wasn't really legally sufficient.
Well, I think it's both, Your Honor.
Doesn't that create an issue for you in terms of not having a transcript? Because we don't know from this record whether or not you raised that objection.
Well, we know
in the trial court.
This was the same fact pattern as Kamen, and Kamen is binding upon this court. It's the same fact pattern. But two, we do have the written objection in the file in the form of the motion for rehearing, which this court has, and I string-cited cases in my reply brief that have allowed that to preserve a record for purposes of an issue like this. That's what this court did in Everett, for instance, just a couple of years ago. And so when we have that written objection...
Wait. We said in that case that you can preserve what amounts to an evidentiary objection by raising it after the fact in a motion for rehearing?
Yes, and this was even better than what happened in Everett, because in Everett that was allowed to be done for the first time on rehearing after a final judgment had already been entered. In this case, we raised the issue before a final judgment had already been entered by filing the written objections in the file before the final judgment had already been entered. And so I submit that based on Kamen, which exists on these same facts,